You feel quite glad once your person known to you joined on a session to share his knowledge. And an important facet which Mr. Karambir Singh Nalwa, an advocate of Punjab High Court, so he practices around all over India in respect of especially the criminal jurisprudence, and I have been knowing him for long. He's also a former additional advocate general Punjab, and he has represented very high-stake matters in the criminal jurisprudence. He thought, why not understand the aspects in respect of right of accused to get the document. In today's journey, he will take us the various aspects with reference to the judicial pronouncements, and we are glad that he's on board in respect of all the which are protected and the old criminal code, and thereafter with others from India. Will not take much time. Being a weekend, I straight away request Wak to take over the session.
Yes, Mr. Chatra, should I take over? Yes, good evening, everyone. First of all, we are celebrating a beautiful year, I suppose, 75 years of our constitutional journey, which means we are celebrating Diamond Jubilee of our constitution. And with the today's topic, which I would like to touch in Beyond Law CLC, and I'm thankful to webinar and Mr. Chatra's team to allow me also to participate and share a little bit of knowledge I have gathered over the years on this subject. And I'm sure in return, I would get some knowledge from my friends attending it and letting me updated with something new and fascinating, which deals with today's subject. In short, it's all about right of an accused to get documents. Now, I remember when I joined profession 25 years ago, things were very different. The provisions though remain the same, but how beautifully the law has now evolved in today's time in 2025. More so, and I must quote, I just want to quote this judgment state because the last of the judgments which I would like to touch today is a Sarla Gupta judgment by the Honorable Supreme Court in May 2025. More so because that judgment flows, it was a bench matter decided by the High Court, but it flows from our High Court, that is Punjab Haryana High Court as well. So when we touch this topic about right of accused to get documents, what becomes very material for us is that compliance of, because we'll be touching with various sections of CrPC as well. But what is the primary section we are virtually dealing with and which becomes important for every lawyer practicing either on the defense side or on the prosecution side to now understand very clearly how the Honorable Supreme Court today is dealing with Section 207 CrPC, which is supply of documents to accused. More so because it has been very well established that so far as compliance of Section 207 is concerned, for ensuring fair trial by giving due opportunity to accused to defend himself. Why it becomes material and why this question has now been settled by the Honorable Supreme Court is because in normal parlance, we all know that we are talking about a subject. An FIR is registered against any of the accused. Investigation is initiated by the investigating agency, be it a specialized agency of the central government or be it a state investigating agency. And all this comes into play as soon as an FIR is registered and an investigation is initiated, which finally culminates into filing of the final report, which in some parlance we call it challan. People who practice in the trial courts are very used to using this word, so am I as well. But we also call it a charge sheet, we also call it a police culmination report, and I'm sure in different states we sometimes refer to that same document in different words as well. So what is important for us today is how do we reach that stage when we talk about getting of documents? I'll take only 2 minutes before I come down to the real issue. And that is certain provisions of CrPC. I'm sure with our new friends, they would be making sure that even though provisions of CrPC I am quoting, but what does BNSS exactly is with regard to the section we are dealing with. But in short, I would like to tell you the two material sections are section 207, 208 CrPC, which in today's term under BNSS is section 230 and section 231 of the BNSS. What is important is that after the FIR is registered, how does our CrPC, I'm sorry, I'll be quoting CrPC again and again and not the provisions of BNSS. The old school, I am still used to quoting sections of CrPC, but I'm sure the team would understand the basic parlance of the same and few definitions which have not changed. Now, to begin with, as soon as an FIR is registered when a cognizable offense is reported, what comes into play is investigation. And investigation is defined in section 2H of the CrPC when we talk about what is an investigation. And then comes section 2R, which talks about police report, a report which is forwarded under section 173(2) of CrPC. Now, once this report is being presented by an investigating agency, be it dealing with after conducting, arresting the accused, be it any recoveries affected from accused, be it a search of a place under section 47 CrPC, or search of an arrested person under section 51 CrPC. The first chapter, chapter 7 of our CrPC, deals with section 91 to 105 CrPC. The most material section out of this chapter being for us being, and the chapter reads as processes to compel the production of things. Now, section 91 talks about summons to produce document. Now, these summons can be sent to an accused. This summons can be sent to a person in custody of certain documents. And simultaneously, section 94, which culminates into search of a place. Once all these processes under previous chapters are covered, we come to an important chapter, which is chapter 12 of CrPC, which deals with 154 to 159. 154, we all know, deals with registration of an FIR. But what is beauty about this chapter is this is where it talks about section 165 talks about search by a police officer. And then comes the most important document, because what I want to touch today only comes into play once a police report under section 173 has been produced, because only then the accused come to know. Now, let me quote an example. A is an accused in an FIR of a cognizable offense. A's place is raided. There are certain documents recovered from him that may go against him, that may go in his favor. And if the investigating agency chooses to not bring on record as part of 173 report documents, which actually help the accused to establish that no offense has been committed, is where this ticklish issue of, which I now say, very happily I say, in the 75th year of our constitutional journey, has been very beautifully clarified by the Honorable Supreme Court. And I don't see any doubt now for any trial court, be it a learned magistrate or an additional session judge or a special judge conducting trial of a warrant case, a complaint case, a specialized offense of a CBI or an ED, everything now in terms of how the Honorable Supreme Court has interpreted investigations of ED as well, we boil down to section 207 CrPC. Now, as I was saying, an offense is committed. There is a document for an accused to say, see here, it is all clear, all clean, no offense stands committed by me. or no offense legally is made out against me on the basis of certain documents which the police has collected, but police deliberately chooses, or the investigating agency deliberately chooses not to make part of 173 report. What does an accused do in that kind of a situation? So once we come to chapter 12, which talks about 173 report, we all know report by a police officer after completion of investigation is termed as a final report. The investigating agency under 173A also has the right of presenting a supplementary report, and not one, maybe more of them. So this is the background how we now reach chapter 16 of CrPC, which deals with section 204 to 210. But what is material for us is section 207 and 208 CrPC. I would, because we'll be dealing with this provision, and I'll be touching this provisions. I'm not quoting any law for you or any judgment prior to 1999 one, which I want to quote, because lawyers of my time would know those were the two beauty judgments which, as defense counsels, we used to repeatedly quote. One is the 99 Shiv Kumar versus Hukam Chand. Many would know, but if not, today is the day we can all learn from each other. And then which came subsequently came a judgment of I think it is 2003, I suppose. Yeah, 2005, State of Odisha versus Devendra Nath Padi. So when we are talking about chapter 16, talks about commencement of proceedings before magistrate, section 204 to 210. But what is material is section 207 CrPC. Including me, we lawyers sometimes who are not appearing before the learned trial court, fail to understand and appreciate the importance of these two provisions of section 207 and 208 CrPC. Let me remind you, friends, we people, when sometimes are practicing in high court, are not dealing with these provisions on daily basis, because these are the provisions which come into play during the course of a trial. But now these issues are repeatedly coming before High Court and Supreme Court. That is the only reason that today in 2025, after the 2022 rules of criminal trials, which I'll be referring to, so 207 CrPC is virtually supply to the accused of copy of police report and other documents. It talks about 5 sub-provisions of it, and then it has 2 provisos also. What is material for us primarily is a provision which talks about I'm reading subclause 3, which talks about the statements recorded under subsection 3 of section 161 of all the persons whom the prosecution proposes to examine as a witness, excluding therefrom any part in regard to which a request for exclusion has been made by the police officer under subsection 6 of section 173. And then is subsection 5, subclause 5, any other document on relevant extract. Now, I was quoting as a defense counsel, we sometimes see, we know documents have been collected. Documents have been collected from the office of your client itself. You are a defense counsel. The documents are of unimpeachable character and sterling quality according to you, and you say no offenses made out. So in 99, when they were dealing with these situations, the first judgment they dealt with was Shiv Kumar versus Hukam Chand. And why Shiv Kumar versus Hukam Chand, though, was talking about duties of a public prosecutor, but it also talks about the legislature reminds the state that the policy must strictly conform to fairness in the trial of an accused. And if your client does not get all those set of documents which are either incriminating him or which are in his favor, mind it, because our criminal jurisprudence, Indian criminal jurisprudence, says that a man is innocent till proved guilty. Now, if the investigating agency either deliberately or taking a foul step. We have certain judgments which says sometimes the investigating agencies have played foul, and there are repeated findings given by the different honorable high courts and Supreme Courts to that effect. And that is where this section comes into play. An accused, this is one of the basic things of our criminal jurisprudence is, an accused is entitled to any legitimate benefit during the trial. And the beauty is the PP, that is a public prosecutor, should not scuttle it and conceal it. And Supreme Court goes further to say duty of a public prosecutor to winch it to the force and make it available to the accused. Now, this judgment of Shiv Kumar Hukamchand, I'll be sharing that compilation with Mr. Chatrat's team for everybody's usage as well for subsequent cases. Shiv Kumar judgment is a 1999 volume 7 SSC 467 Shiv Kumar versus Hukamchand. We read para 13 of that judgment. It crystallizes it what the Supreme Court even wanted to say prior to 1999 and how beautifully the law has evolved in our country from 1999 to 2025. And that is why I say I'm going to be quoting the last judgment of May 2025, a 3 judges bench judgment in the case of Sarla Gupta, which was an ED matter, I think ED or a CBI matter. Once this issue was being addressed before the Honorable Supreme Court, the court was the accused and defense counsels were always facing this dilemma that can we approach, and this is where lawyers for practicing primarily in High Court would recollect this judgment, the 2005 judgment of State of Odisha versus Debinder Nath Padi. A 2005 judgment, I'll share the citation with you, is a 2005 volume 1 SSC 568, again a 3 judges bench judgment. For your knowledge, para 18 and 29 would be material. But why this judgment came was because there was a situation which was arising. An accused comes, and I'm sorry to quote a judgment, we all know who practice in High Court, we coming under 482, seeking quashing, we rely on Bhajan Lal quite a lot. Across the country, we rely on Bhajan Lal. And certain provisions of para 108 of Bhajan Lal says that if the offense is not made out, is not cognizable, no illegality, a lot of factors are there. Now, let's say a particular accused or a defense counsel is able to establish that I have clinching evidence, undisputed evidence of unsuppressed quality and standard to say no offense is made out. Why this was there? Because there is another provision of 91 CrPC, as I said. The 91 CrPC is summons to produce the document. Now, what does an accused do? There is a document of unimpeachable character and sterling quality, but the prosecution chooses not to make those documents part of 173 report. What does an accused counsel or a defense counsel do in that situation? We rely on section 91 CrPC, and when we move an application as a defense counsel to say that these documents are not part of 173 report and they should be summoned, and the beauty is should be considered before the charges are framed. Now, this issue went before the Honorable Supreme Court and it was referred to a 3-judge bench. And the Honorable Supreme Court and 3 judges bench at that stage in 99 crystallized that no, the trial court cannot look into documents even if they are of unimpeachable character and sterling quality at the stage of framing the charge. And they will have to the trial court will have to restrict itself to documents forming part of 173 report itself. So when this issue came before the High Court and the Supreme Court crystallized it, that be it an accused is coming under 482 CrPC, be it an accused is coming under Article 226 of Constitution of India, what right does it flow? At that stage in 2005, Supreme Court said, whether an accused himself is producing those set of documents. So please try and understand, you are a defense counsel, your client has provided all the set of documents either directly or through a lawyer or through a representation to an investigating officer, but the investigating officer chooses not to make those documents part of 173 report. What do we do as a defense counsel at that stage? And what is the duty of a public prosecutor, and what is the duty of a court as well? As we go further, this has been very beautifully given by the Honorable Supreme Court, and I'm repeating this word because as a defense counsel and having served the state and the investigating agencies, the way the law has now progressed, and that is why this 75 years is becoming very important for us, because we are getting judgments in last couple of years from Honorable Supreme Court where a lot of issues are being closed for once and for all, and the law is being settled very beautifully, not to leave any gray area of a new interpretation by either of the sides. So when the Honorable Supreme Court was dealing with this situation, Supreme Court said, no, the trial court will not consider those documents which are not part of 173 report. But it gave liberty to an accused to approach the Honorable High Court straightaway under 482 or 226 of the Constitution of India and place those documents on record, asking the High Court to exercise its inherent power under 482 or its writ jurisdiction under 226 to consider those documents and then go on to quash the FIR and maybe a 173 report also. So till 99, the law was trial court would not rely upon that set of documents, but High Court under 482 and 226, even though they are not part of 173 report, can be looked into by the High Court and then quash the proceedings on the basis of those unimpeachable documents of sterling quality, where the High Court is able to establish that on the basis of these documents, there is no question of any trial to proceed, and we must exercise a power under 482. So this was 2005. And there is one celebrated, I would say infamously celebrated case of the Jessica Lal murder case. The case is reported as Siddharth Vasisht alias Manu Sharma. When I started my profession on the criminal side with my guru, Mr. Siddharth Luthra, I got an opportunity to be one of the defense counsels in the trial in this case as well, way back in 2000, 2001. But how the Supreme Court finally culminated, only one background you would know. That case, the accused was acquitted by the trial court. State went in appeal. High Court reversed the judgment. He was convicted. Accused went to Honorable Supreme Court, challenged his conviction. The conviction was upheld by the Honorable Supreme Court. Now, that judgment of Siddharth Vasisht alias Manu Sharma is 2010, volume 6, SSC, page 1. I must tell all lawyers who are primarily into criminal practice must read this judgment, because other than the issue I'm going to touch, this judgment really helps in a defense counsel on a lot of subjects and issues of criminal law. But for us and for today's case, we all know that so far as we are dealing with issues of right of an accused to two documents. So in this judgment, the Honorable Supreme Court touched three material issues which are so beautifully interrelated to what we want to say. That is supply of documents. And remind you again, we are dealing with a case where the Supreme Court was hearing an appeal against conviction. But the issue of section 207, 208 arose there as well. The first issue was duties of a public prosecutor so far as section 207, 208 is concerned. The second thing the Honorable Supreme Court could directly raise was powers and duty of the court itself, who is dealing with the trial and obviously also dealing with 207, 208. And then finally culminating the law as in 2010 with regard to section 207 and 208 CrPC of supply of documents. Now, what the Honorable Supreme Court finally was, so you must note down, my friends, I would love to share that. The beauty of where the court talks about the duty of a public prosecutor in this issue, important issue of supply of documents, because the Supreme Court categorically from paras 183 to 187 touched the role of a public prosecutor and his duty of disclosure. This issue was raised, and this argument was raised before the Honorable Supreme Court by legendary lawyer Mr. Ramjet Milani, who was the defense counsel at that stage, starting with who is a public prosecutor, and section 24 of CrPC talks about public prosecutor and what's his duties is. What Supreme Court says, the legislature reminds the state that the policy must strictly conform to fairness in the trial of an accused in a sessions court. Don't fixate yourself with the session court. The principle remains the same, be it a magisterial court as well. And Supreme Court said it is the duty of the public prosecutor to winch it to the force and make it available to the accused, even if the defense counsel overlooked it. Now, please try and understand a situation. You, as a defense counsel, would be knowing only those set of documents which the accused you are representing or your client can tell you about. But an investigating agency is conducting investigation from various different sources, from various different people, and there may be certain set of documents which are able to establish to the court that yes, no offense is made out against an accused, or those set of documents, if part of 173 report, there cannot be a situation that court may go on to proceed even to frame charges against you. And why this issue is important, as we say repeatedly, the documents which are part of which favor the accused are invariably not made part of 173 report. So the Honorable Supreme Court then says, again, I said para 183 to 188, it went on to say public prosecutor has wider set of duties than to merely ensure the accused is punished. The duties of ensuring fair play in the proceedings, all relevant facts, and brought before the court in order of determination on truth and justice. For all the parties, when we say all the parties, it is not only the accused, it is not only the victim, the state, and everybody. It must be noted that these duties do not allow the prosecutor to be lax in any of his duties as against the accused as well. So after touching these issues, Supreme Court also says, it says CrPC imposes, in para 190 it talks about it, very beautifully written. CrPC imposes a statutory obligation on the public prosecutor to disclose certain evidence to the defense, which is brought out by section 207 and 208. But however, what happens to that situation? Or I would like to add, हम लोग जब कई बार ट्रायल कोर्ट जाते हैं as a defense counsel, we are unable to at that stage, as a beginning lawyer, understand the importance of these two provisions. Please be rest assured, हम ट्रायल कोर्ट के जो lawyers भी हैं, and every criminal lawyer I believe and I have learned from my seniors, can never say I'm a lawyer of High Court and Supreme Court. Because the beauty of criminal law or any law starts from the trial court. And you would recollect, when we are only doing certain appeals, we are sometimes irritated reading the cross to say, यार ये ट्रायल कोर्ट के वकील ने सवाल पूछा ही क्यों नहीं accused को या witness को, या ये document कोर्ट पे लाया है क्यों नहीं गया on record. And then that's where when we are doing appeals, we get sometimes irritated that why have these lapses occurred during the trial. So we as defense counsels, or even as a duty of a public prosecutor, as I said, I've been on the other side on 3 different occasions, but the unparalleled duty is, be it we on this side of the dais or that side on the prosecutor's side, we know the basic principle. We are officers of the court, and we have to bring the correct law to the knowledge of the court and share that information and that law, be it against us or be it in our favor, and that principle and that duty applies to the public prosecutor as well. I remember attending one of those chapters, and when my colleague, Ms. Tanu Bedi, was addressing on the principles of bail and regular bail and anticipatory bail, and until was being quoted. And you would recollect, now we are coming to that situation where the Honorable Supreme Court is repeatedly focusing also on duties of a public prosecutor to bring the correct law to the knowledge of the presiding officer, the duties of the presiding officer by the guidelines being issued repeatedly, the directions being issued repeatedly, the rules being framed repeatedly. So that is why these judgments sometimes become important. And it pleases me to say that there was and there is a similar provision, and because we've been following the English law, there is a similar situation before the English law as well, where there were a act by the name of Criminal Procedures and Investigation Act 1996 in England. There was a common law, then the English law. This new act was framed to deal with these situations, and I'm happy to say when we come down to the last judgment, I'll be happy to say that we are much and way ahead of lot of jurisdictions around the world in providing this kind of benefit. And I must say that today in Indian criminal jurisprudence, an accused is placed in somewhat advantageous position. So I'll come back to Manu Sharma's judgment. The Honorable Supreme Court, while dealing with the situation, repeatedly dealt with and said, it goes on. Let me read these 6 lines, very important, from different paragraphs of 201 and 203 of Manu Sharma's judgment. I'm quoting and I'm referring to these paragraphs from SSC online. It says, in some cases, besides investigation being effective, the accused may have to prove miscarriage of justice, but once it is shown, the accused would be entitled to the benefit in accordance with law. And it says, Supreme Court says, it is established canon of just, fair, and transparent investigation is the right of defense of an accused. An accused may be entitled to ask for certain documents during the course of inquiry and trial by the court. And then it goes on to examine section 170 to 173. So this was 2010. And then comes a subsequent judgment. This was a suo motu cognizance taken by the Honorable Supreme Court in 2017. A judgment is dated 30th of March 2017. It was a suo motu case, Manoj versus State of Madhya Pradesh. The judgment of the Honorable Supreme Court is dated 30th of March 2017. And the para is with regard to, and the relevant para for you would be para 12. And it dealt with absence of uniform guidelines as to, because this issue is coming, accused is moving an application. There is a set of documents collected by the investigating agency from an accused office itself. And even those set of documents, because they save the accused, are not made part of 173 report. Then we all know a celebrated judgment of Tarun Tyagi versus CBI. This is a 2017 judgment. The citation would be 2017, Volume 4, SSC 490. And the relevant paras are paras 7 to 14 of this judgment. Now, what is important is that Tarun Tyagi dealt with and raised this issue for the first time to say, what is the object of Section 207 CrPC? Now, this question was framed in this particular terms itself because they were saying, is in present situation, Section 207 being complied in all its objects and reasons by the investigating agencies or not? And therefore, the moot question was with regard to as to, and the word used in the judgment itself, let me use that exact word when they say right to get such copies is statutorily recognized under Section 207 CrPC, which is the hallmark of a fair trial, that every document relied upon by the prosecution has to be supplied to defense and accused. So Tarun Tyagi was again dealing with this judgment, and then comes the next judgment in 2020, that is P. Gopalakrishnan, which is a 2020 volume 9 SSC 161 judgment. The central issue was here obligation of an investigating officer. As I said, and I have to repeat this word, because invariably, even today, all the set of documents which sometimes save the accused are not being made part of 173 report. And that is where, as I said, the court goes on to say, as back in Manu Sharma's case in 2010, the duty of a public prosecutor is not serving the investigating agency. A public prosecutor is not a lawyer representing the investigating agency. Public prosecutor is a lawyer representing the state. And the duty of the state and a duty of its officer is to bring and unfold everything before the court, whether it goes in his favor or whether it goes against him. So P. Gopalakrishnan dealt with these issues. And then we know that in 2021, draft rules of criminal practices were made. It was repeatedly modified. Series of discussions were gone on after the judgment of the Honorable Supreme Court in Manoj Kumar. And then there is another judgment of Manjeet Singh Khera versus State of Maharashtra. But 2021 rules were framed, and Rule 4 became very important for us of these amended rules. And I would love to read that particular line for you for import is because it is touched in P. Punnaswamy. And I'm sorry, in between we'll also say, we all know now, we rely on that judgment quite a lot as that criminal trials guidelines regarding inadequacies and deficiencies versus state of Andhra Pradesh. That judgment for every lawyer is a very important judgment who's practicing on the criminal trial side. It is the 2021 volume 10 SSC 598, a 3 judges bench Supreme Court judgment. To begin with, even if you recollect and read para 11 of this judgment, it will give you a complete picture. What does it talk about? Now, when this judgment came, it dealt with the Rule 4, and it talks about the Rule 4 also talked about that as to what would be the situation where the documents are not being supplied to an accused. And the rule which regard to para 4 I'm talking about came into being, and this rule was primarily quoted. Just give me a second, guys. Yeah, this rule is very important, and this rule is so far as today I'm reading it for you from a Punnaswamy judgment, which I'll be also referring to, is the 2022. After, as I said, the 21 criminal trial judgment, 2022 SSC Online Supreme Court 1543 P. Punnaswamy versus State of Tamil Nadu. And this rule talks about supply of documents under Section 173, 207, and 208 CrPC. This is the rule which they framed. And it talks about every accused shall be supplied with statements of witnesses recorded under Section 161 and 164 CrPC, and a list of documents, material, objects, and exhibits seized during investigation and relied upon by the investigating officer in accordance with Section 207, 208 CrPC. This we know was the law earlier as well. But what was also important is that it went on with coming with an explanation to say the list of statements, documents, material objects, and exhibits self-specify documents, material, and exhibits that are not relied upon by the investigating officer. So the rules come in 2020, when, as I said, from 99, or we go back to the judgments prior to that, and that's why I started only with 2010 Manu Sharma, because Manu Sharma's judgment and with the arguments raised by legendary Mr. Ramjet Malani, this issue was dealt in detail. And that is how this rule was framed, that documents which they have collected, not relied upon, because we know this situation we face as a defense counsel, only those documents which are going in favor of the investigating agency or the prosecution case are made part of the challan, which accordingly has now been interpreted and settled. As of now, we have reached the stage that the list of documents not relied upon shall be supplied to the accused. So from 2022 came a situation after Punnu Swami's judgment, and in the meantime, we all know that celebrated case of XYZ, a judgment of the Delhi High Court, where an accused had gone to the Honorable Supreme Court. An application was moved by the accused before the trial court. Trial court passed an order. Accused went to Delhi High Court. This case has now been concluded because CBI challenged that issue before the Honorable Supreme Court, and Supreme Court said nothing doing. It has to be the accused will get a copy of those documents as well, which do not form part of 173 report as well. A specific application to that effect was moved by an accused. After that judgment of 2022, Punnu Swami, because I would want 10 minutes of anything which I can come up with, or which any query which is by any of my friends here, is the most important. Why I shared this view with Mr. Chatrat as well is the latest judgment of the Honorable Supreme Court, and more so lawyers who are practicing on the specialized field of CBI and ED cases are repeatedly facing these issues. Because one query can arise, what do we do? You have not touched the issue. Is this provision available in a complaint case as well? Yes, the answer is yes when we talk about Section 208 and Section 238 also, because it's the duty of the court to ensure that it has been complied with. Now, the final judgment which I would like to refer when we talk about this issue is Sarla Gupta, a latest judgment of the Honorable Supreme Court, which is dated 7th of May 2025. It's a 3 judges bench judgment of the Honorable Supreme Court, and the citation is 2025 SSC Online Supreme Court 1063. Various contentions were raised. There was an order, the application moved by a set of accused in a case of ED. Now, we all know the ED has to file a complaint, and therefore we must understand and appreciate that the provisions of 2707, 208 even comes into play in complaint cases, be it a complaint, a private complaint, or be it be an ED's complaint, but the procedure would remain the same. So this was a situation where an accused moved an application for certain set of documents which were collected from his office only during the raid. Now, they are collected by the ED during the raid, but they are not made part of the culmination report, which is part of the complaint which is filed by the ED. So therefore, an accused comes up before a trial court and the special court and moves an application before the learned special judge under Section 207 CrPC to say that I need these documents. These documents were collected from my office itself. They are not part of the police, the ED complaint. And what do I do? Now, those application was dismissed by the learned trial court. It is a bunch judgment. But one of the issue arises from our High Court itself, which is Punjab Haryana High Court. The order came to Honorable High Court. It was again dismissed. So he had to go under 482. It was dismissed. The issue reaches before the Honorable Supreme Court. And we are as repeatedly reading. I feel very happy and privileged to refer to judgment of this. Author is Justice Oak, Abhay S. Oak from the Honorable Supreme Court. And there are a series of judgments which are coming from his bench, and it as a student of law, it pleases me because it is actually laying to rest a lot of gray areas which we lawyers on the criminal side face, be it a public prosecutor or be it defense counsel. So the Honorable Supreme Court dealt with this issue, dealt with the order. If we're talking about Section 17 of PMLA, there is a search and seizure. Section 18 of PMLA, search of persons. And the issue to be decided was para 19. This para 19, permit me to read this for you. It is very important. In this case, I'm reading para 19 from the SSC online. In this case, we are called upon to decide only the issue of supply of seized documents and records. Now, I said, police has or ED has collected documents from your client's office itself. They may help him, but they are not part of 173 report, or they are not part of the complaint or the investigation culminated by them. So this was the question, and the Honorable Supreme Court finally laid to rest by relating a lot of conclusions, and is held at that stage. Para 55 are the conclusions. I'm sorry, we are running short of time, so I'll conclude it in 5 minutes so that there can be some meaningful discussion on this, and I'm open to that, and obviously to learn a bit from all of you as well. Conclusions are in para 55. You must read this judgment. As I said, every lawyer practicing on the criminal side, the rights of an accused to seek documents not relied upon by the prosecution. So then it talks about all, when you read this judgment, it talks about all those judgments which I've discussed till now. It talks about Shiv Kumar Hukamchand. It talks about Manu Sharma's case. It talks about Davinder Nath Padi from 2000. So I'm 99, we are in 2025. You read this judgment, you would find most of these judgments have been quoted and relied upon in one way or the other by the Honorable Supreme Court. It beautifully refers to para 18 of Manu Sharma's judgment in para 40 of this judgment. As I said, Sarla Gupta's case. And then finally, the Honorable Supreme Court, and I'm just to re-quote for you, is justice. Yes, please let me read this line. They've touched it from Manu Sharma. The perception of prejudice for the accused to develop, and if the same is founded on a reasonable basis, it is the duty of the court as well as the prosecution to ensure that the accused should not be made to labor under any such perception, and the same must be put to rest at the earliest. Such a view, according to us, is an unalienable attribute of the process of a fair trial that Article 21 guarantees to every accused. So Article 21 comes into play when we are dealing with Section 207 and 208 as well, because it is a right of fair trial, which is one of the constitutional rights to every citizen and anybody facing that situation in a court of law. And finally, they culminated. So today, the law as it stands is that documents, para 55 of this judgment are laid down conclusions. There are 6 to 7, almost 10 conclusions by the Honorable Supreme Court. And it laid to rest even an ED case, because in a lot of ED cases, an argument was being raised by the London prosecutor with regard to the documents, because we know ED is a case which comes into play when there is a predicate offense as well, be it an investigating agency, a state investigating agency, or a specialized investigating agency as CBI. So there is a predicate offense, challan is presented in that offense. Those set of documents only are made part of the complaint which is filed by the ED, and nothing which is collected by the CBI or by the ED independently which goes in favor of the accused ever comes before the court. So the court said, we hold that a copy of the list of statements, documents, and material objects and exhibits that are not relied upon by the investigating officer must also be furnished to the accused. So we have a right today to get those documents, a detail and list of those documents. But today, in terms of Section 91, I cannot use those list of documents because I don't have the document. I only have a list of those documents and materials. I cannot use them at the stage of arguments on charge. I'll have to, within the framework of as the law today is before the Honorable Supreme Court, I can only rely upon the documents which are part of 173 report. So what happened to these list of documents? And I find there are certain documents to my favor. I will be using these documents by moving an application independently under Section 91 CrPC, either to re-summon a prosecution witness under Section 311 and put these documents to him for further cross-examination, which is a right of an accused under section 311. Or be it after my statement under 313, and my defense evidence, I want all those documents to be summoned, and the court would be obliged and duty bound to summon those set of documents and witnesses so that I am able to establish my defense on the basis of the documents, as I said, we begin with, which are in the knowledge or collected by an investigating agency, but knowingly or unknowingly or deliberately not made part of 173 report. Now, what it also says is, I'm reading the conclusion F. What is important is, that's where it says that when at the stage of defense evidence of the accused, documents are produced. Now, I said I move an application under 91 CrPC. Those set of documents or witnesses have to be produced, are produced on the prayer of the accused, and the accused desires to cross-examine any of the prosecution witnesses based on the said documents. Now, please understand the situation. When you cross-examine a witness, a prosecution witness, you are only basing yourself on the documents which are part of 173 report. These documents come later on because you moved an application, you come to know about the existence of those documents because a list of documents have to be produced. And please remember, it is the duty of the court in terms of the guidelines. It is the duty of the public prosecutor and the court in terms of the rules of 2021 or the guidelines issued by the Supreme Court. But knowingly, unknowingly, this is not being implemented in practice. So as a defense counsel or maybe as a public prosecutor, let's bring it before the knowledge of the court that today this is the law of the land as laid down by the Honorable Supreme Court. So please understand and appreciate the importance and beauty of these provisions. And it says it will be open for me to call back those prosecution witnesses and use these very documents to cross-examine a prosecution witness. And it also goes on to say the reason is that the right to effectively cross-examine the prosecution witness is also a part of the right to have a fair trial. The accused can exercise this right even if evidence of both sides is closed. So why and how this becomes important for us is that even today we have a situation that I may not be able to use those documents at the time of charge, but I will come to know as a defense counsel that these are the list of documents which are in possession of the investigating agency, but have not been paid up part of 173 report. And therefore, I will have to later on rely upon, after getting this list of these documents on section 91 CrPC, use these documents, summon these documents to cross-examine a prosecution witness or to use them in my defense as well. So in 2025, we have this situation in light of this judgment and the rules. And please don't forget as a defense counsel to move an application under section 207. And even if we are dealing with this situation primarily before the Honorable High Court, please understand and appreciate the importance and the beauty of these two provisions when you are a defense counsel. So I'm open to anything to be discussed or any question put to me, and I'll try my best to answer it if I can with whatever limited knowledge I have on the subject. Yes, Mr. Chhatrat, please.
Just checking it out. There's only one question, but that's a long question. You can read in the chat.
Oh yeah, I'll do that, and I'll share it with you, Mr. Chhatrat. I'll share this entire compilation with you. Whosoever has done the homework, why not everybody take the benefit of it as a counsel? And the beauty of law, as I've learned from Mr. Luthra and Mr. Chima, is we must share the law with each other. Let's try and bring everybody on a page where we learn new law and a new subject or anything which helps us as a fellow colleague. I'm open to even receive it from you people. So I'll be sharing this entire compilation from 99 till 2025 with the relevant paragraphs as well. And once you read these judgments, I'm sure how I'm able to bring this subject to you today, you would find it as easy tomorrow after reading this compilation and these judgments.
There's only one question. Complainant has filed a police complaint against an accused for misappropriation of funds.
Right.
The complaint was not registered as FIR. The police calls the twice by issuing notice for inquiry.
Right.
The accused pleads innocence. The police did not supply the accused a copy of the complaint. Later, the complaint again files a complaint based on facts, which is registered as an FIR.
Right.
Accused obtains bail and files of the petition and gets the stay. Can the accused has a right to obtain the first complaint not registered under the FIR?
Absolutely, and I would say that would also become, because you will have to check that subsequent complaint wherein that they have registered an FIR. So preliminary issue would be forget any law on your side. The preliminary issue would be, has there been a disclosure by the complainant in his subsequent complaint that I had also moved an application or a complaint earlier? And we know the basic principles will not change without coming to section 207, 208. The preliminary issue of concealment of facts and not bringing all these documents on record is an important factor which would help us otherwise also. And as I said, even in a complaint case, because once you read Sarla Gupta from 99 till 2025, the picture is going to be clear. And you would also realize that the principles of 208 are applicable in a complaint case as well. So let's say, as Mr. Chatrat has just brought this issue before me, that there is a private complaint, police fails to register an FIR and says no offense is made out. We come to a second situation, a second complaint is filed for XYZ reasons and FIR is registered. Yes, be it at the stage of bail or be it whatever the stage may be, and that is where again the beauty of knowing the law, the beauty of a drafting, which Mr. Chatrat's previous sessions have touched so beautifully at number of occasions, of guiding everybody on this issue. So drafting also becomes a very important issue. Once we don't know the provisions of CrPC or applicable provisions, or we don't know the latest law, our drafting skills would also be very small and quite poor as well. It is our duty as an officer of the court to tell the court the latest law on the subject. Trust me, guys, even if it goes against you, right, as an officer of the court, it is very important to tell the court what is the correct case. As an officer of the court, yes, we are defending our accused, but we can't go and forget the basic ethics of telling the court what is the correct law on the subject. So I think, Mr. Chatra, whosoever question is, even if it's a complaint filed and subsequently an FIR is registered, because section 207 will only come to play at the time of once the challan has been presented. As I said, a wrongly registered FIR, you may quote all those judgments, but section 207 may not come into play at the time of the second complaint and a FIR by concealing the facts of the first complaint. You may culminate it in shape of your drafting and provisions, but section 207, 208 will not come into play till the time 173 report has been presented by the investigating agency.
Before we take the second question, Shreya says, no question, but would love to thank you, sir, for such a wonderful session and giving us such a good information. Thank you so much, sir. And the next question is, does the victim de facto complainant have the same right to get the documents from the same from the state?
I'm very happy with this question. This is something, because we've been talking today only about as defense counsel or a duty of a public prosecutor, and let's say we are representing. Yes. Let's say there is a situation here where the complainant and the police is siding with an accused. Let's take the other example as well. And documents which actually clinch the issue in favor of the complainant, and they are not made part of 173 report. What is the right available with the complainant? Now, section 207 does talk about rights of an accused to get documents, but section 156(3) will come into play for a complainant, and the complainant may not wait. If he comes to know that the investigating agency is playing foul, it may move an application under 156(3). But let's say the investigating agency has played foul and they have presented a cancellation report in favor of the accused. We know in terms of the law on this subject that cancellation report cannot be accepted till a complainant is given an opportunity of hearing. Complainant will have a right to move an application under 156(3) asking for further investigation. And in that application, it can actually jot down that on so-and-so date, I was joined investigation and this set of documents were collected, which clinch the issue to say that offense has been committed by the accused. This is where, as you had covered in your previous, that's where the beauty of drafting an application also comes into play. So the complainant's right in a similar situation would arise under 156(3), where complainant will bring on record that these are the documents which have deliberately not been collected by the investigating agency. And if these set of documents were part of 173 report, there was no question that there would have been a cancellation report, and it would only have been a report bringing the evidence on record against the accused.
Lakshya Singh says, if the quality of the documents supplied are not legible as such, can you ask the prosecution to provide for a fair copy?
Oh, yes. That is the bare minimum thing. Let's say all these judgments were never existing. And we are only talking about a challan presented in section 207. See, because when you read section 207, you should read section 238 also, because it puts burden on the court. Court will have to ensure that section 207 has been complied with. Section 238 CrPC talks about this very thing. Just give me a second, please. Yes, I'm right. It is section 238 CrPC. I'm sorry, I'm repeatedly quoting CrPC, not the BNSS, but we can do it from that tabular form. It talks about that compliance with section 207. So let's say, as Mr. Chatra was just asking, that there are documents which are not legible. Or I say I go a step further. We do that repeatedly. A document is of 10 pages and only 4 have been placed on record and 6 are missing. So that will be one simple application under 207 to say that the document is incomplete or the document is not legible, which will be given. And please remember, whenever you are quoting this, don't forget to quote the rule 4 of 21 rules or the judgment of Sarla Gupta or any previous judgment or 21 judgment, 22 judgment, to say it is the duty of the court and the PP to ensure that list of documents not relied upon by the prosecution is also provided. So don't base your application only to ask for that these are the illegible documents or this is an incomplete document. This document is of 10 pages. Please make another paragraph in your application so that you are saying so on record in black and white that there are other documents. Please provide me a list of those documents as well.
Police officers should give FIR before the arrest to the accused / to the family members of the accused, or the accused has to take the FIR from court only?
No, yes, though we don't deal with this judgment, but there is another beautiful judgment. I read it last month only. Pankaj Bansal's judgment. We are dealing with it with regard to why Pankaj Bansal, though the topic is not connected, but I would love to answer it, because we've been dealing with those judgments of Antil, Ms. Tanu Bedi had done that show, and Arnesh Kumar, Section 41A, importance and everything. Yes, not only is the duty of the investigating agency to inform the family members about the arrest, they will have to give grounds of arrest as well. Grounds of arrest as well, and obviously giving a copy of the FIR or a complaint, because Pankaj Bansal was again an ED case. It's a 2024 judgment dealing with whosoever has put this question. If you read 2024 volume 7 SSC 576, that's a Pankaj Bansal versus Union of India. Again, a judgment flowing from Punjab Haryana High Court itself. And why it pleases me is because when a judgment is going from your High Court, and whatever way the judgment is coming from the Honorable Supreme Court, at least in your own High Court, it becomes quite easy to rely on those judgments. So my friend who has put this query with regard to a copy of the FIR, yes, it is the right of an accused. And I go a step further, forget the copy of an FIR. Even the grounds of arrest have to be disclosed, more so in an ED case. 41A CrPC with regard to a normal investigating agency also is important. So I would say yes, copy of the FIR is the bare minimum thing which will come into play.
Is it necessary to provide documents to the accused and his counsel at the time of PCR?
At the time of?
PCR.
Sorry, at the time of I couldn't get the last word.
PCR.
I'm sorry, Mr. Chhatrat, I still can't get the
PCR.
PCR. Just what is PCR you talking about?
Yes, I'm also checking.
Sorry, I don't know. I don't understand what whosoever question is PCR in what terms he's talking about PCR. Is he talking about the police remand period? What is he talking about? What the question is about?
There's no further expression forthcoming. Police custody.
Yeah, so police charge, as I said, somebody has used this word police charge sheet. Please remember, be it a police charge sheet, which is also covered, 173 report. It may, people in common parlance in North India also call it a challan. Trial court judges and lawyers also refer to a challan, whether it is a police charge sheet, be it a report under 173, be it a challan, or be it in any other way, because I've dealt with cases of Maharashtra and all, I've seen they use some different words. I'm unable to use it, remember that word exactly. But yes, as soon as the police charge report is presented, section 207 comes into play. Please remember, police, whether your client is on bail or anticipatory bail, police completes its investigation, presents that report, which you want to address it at PCR. As soon as that report is presented, on the next date when the accused is summoned, he will be given the complete set of documents, which is, as per the trial court, compliance of section 207. But please remember one thing, I've dealt with cases. This is here the copy of the challan or the PCR is presented to you. On the same day, the judges are framing, the learned magistrates are framing charge as well. So you have not seen the challan. You don't know whether the challan is complete or not. You don't know whether the documents are legible or illegible. You don't know whether the documents are complete. You are not aware of list of documents not relied upon by the investigating agency. Please tell the court that the law is very clear. We have to be provided with a list of documents, and you have to give me time to go through the challan, and then only an accused or an accused counsel will say that yes, 207 stands complied with, because everything has been provided to me. So PCR would be same thing, Mr. Chatrat, what we may call a report under 173 or challan in Hindi parlance.
So, Mr. Nalwa, for sharing your knowledge. And tomorrow, friends can join and understand the nuances of the environmental law. I'm just sharing the topic. This is major environmental challenges in India by Mr. Professor P.R. Subramania. Do join us at 6 p.m. tomorrow. Thank you, Mr. Nalwa, for sharing your.
Thank you, everyone, and happy Diamond Jubilee celebration that is going on across the country for everybody, and we are all a happy part of it. Thanks to Mr. Chatrat for all of that. God bless you and have a nice weekend.